Hi, everyone. Welcome to episode 102 of the Immigration Lawyers Podcast. I'm going to be interviewing and reviewing a case, a federal court case actually, with immigration attorney Jeff Joseph. He has an interesting federal court case that's moving through the system with a lot of twists and turns that you should know about. On a side note, I wanted to thank Anuj, the founder of FeedSpot, for listing this program as one of the top 15 immigration podcasts on the web. I also want to give a shout out to all the new listeners and existing listeners. I've been trying my best to reach out to as many of you as I can to have a phone call to get to know each and every one of you better as we've been connecting more and more, especially through LinkedIn. And it's been a great experience. Before starting, I wanted to remind other listeners that the Immigration Lawyers Toolbox is available on LinkedIn, and it has a LinkedIn page, and it's growing. And I post job openings from across the country, as well as other special videos and pieces of information that can help you become better immigration attorneys that you can't find anywhere else. Please check it out and click on the follow button. And also connect with me on my personal LinkedIn page so I can get to know you that way too, and set up a time to talk to get to know more about your practice and how immigration law is treating you. With that, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Thank you for tuning into this midweek recap for federal litigation regards in particular to employment-based. We have a great guest today, Jeff Joseph. And Jeff has his own firm out in Colorado and has been doing some great litigation that's been in the news. And I wanted to talk with him about that and what that entails, and just litigation in general in the federal litigation area that a lot of immigration attorneys are trying to get into, or are starting to get into. With that, Jeff, why don't you tell us a little about yourself and your background?
Sure. So I sort of fell into immigration by accident. When I was in law school, I was geared to be a public defender and had a lot of trial experience. And so, but I did have a passion for immigration. It just wasn't a lot of opportunities in Denver. And about a month before graduation, a friend of mine, his mother is an immigration attorney, and he said, you should apply. She just lost one of her associates. And so I did. And but I really wanted, and it was a corporate immigration law firm, business immigration law firm, and I really wanted to keep my litigation hat on. So I asked if I could start the removal practice, and so we did that. And after about a year and a half, I ended up leaving and starting my own practice. But it was heavily litigation based at the beginning. Mm-hmm. But that combination of corporate experience plus the ability to litigate was kind of what my entree was into federal court. I wanted more than just litigating cases in immigration court.
So did you start as a solo and you worked your way up to a bigger practice with associates and partners?
Yeah, so I started the practice in December 1998. About 6 months later, my wife, who was at the public defender's office, she joined me. Mm-hmm. And so we've worked together for the past 20 years. So
that's wonderful.
Now we're a firm of 10 lawyers, and I think we're a total staff of like 24. So.
Oh, it's wonderful. So 20 years of doing this and you're still waking up excited to go to work. That's good.
Absolutely. I love what I do, especially when it involves suing the government.
Well, that's a good segue. So way I learned about you is it was in Bloomberg and Forbes and all this kind of stuff that you had filed an H-2A lawsuit. Is it? Which category is it?
It's H-2B.
H-2B, I'm sorry. H-2B with related to Guam. And why don't you fill us in on the facts of and how it became such an interesting case because of what the magistrate said?
Sure. So it's actually the facts sort of drive this case, and really what really compelled me to take it on because I knew it would be a winner. Mm-hmm. The case involves Guam, which if you've never been there or don't know where it is way out isolated in the middle of nowhere.
Yeah.
And so there's no skilled labor on the island, and there's a ton of construction because the Marines are moving their Marine base from Okinawa to Guam. Mm-hmm. So there's a military buildup, a Marine buildup, plus all of the infrastructure that goes along with it. It requires a lot of skilled labor. So they've always relied on the H-2B program for decades and have had as much as 4,000 approvals a year with almost zero denials. And starting in 2012, it went from 4,000 approvals to 12 in one year with no explanation. And obviously, these contracts are multi-million dollar contracts. They have mitigated damages clauses if you do not complete the contracts on time that are worth $100,000 a day. A lot of stakes involved when skilled labor was taken off the table. So there was a lot of legislative work, trying to work through Congress to get it done. There was a lot of liaison work with the agency, and ultimately the only answer was to sue. And so we filed a class action arguing that the government had essentially changed the law.
What year was it that these denials started coming into being?
2012, and they have consistently been at zero approval since then.
So that was pre-Trump. Do you have any indication of what the trigger would be that they did this?
We have no actual knowledge of what the trigger was, but the H-2B clampdown started right after Obama basically did the returning worker exemption in the spending bill. He signed off on it. And our understanding is that the labor unions were very upset that they weren't consulted about that before it was added to the bill last minute. And so the result was a clampdown on H-2Bs. That's anecdotally what we've heard.
And I mean, the projects they're working on is military related, and congressional help, all that kind of stuff, didn't make a difference?
No, it really didn't. I mean, we actually met with several individuals representing the armed forces, and their position was sue us. Originally, there was a lot of concern among the companies that there would be backlash, right? If we sue the government, well, they're going to put us on a blacklist for contracts. And the military basically said, sue us. It's the only way you're going to accomplish anything. And don't worry about a blacklist because we get sued by contractors every day. So they were very comfortable with the fact that the military is, from our perspective, is on our side. In fact, every agency of the government is on our side. The Department of Labor has already certified these. The Guam Department of Labor has testified as an expert on our side in the case. The governor of Guam, the Department of Defense, I mean, across the board, the only agency that's sort of recalcitrant is USCIS.
And it shows there's something going on behind the scenes where someone's making a decision, that just a blanket decision. Okay, so you sued them, and it's a good point you made, which is don't be afraid of suing. There's no blacklist. This is what scares off a lot of people from moving forward with litigation. So you filed suit in federal court. Which district, which circuit or district, which district would it be?
This is the United States District Court for Guam.
For Guam, okay, that's
yeah. And it's in the Ninth Circuit, so we're reliant on Ninth Circuit, which is good in terms of injunctive relief and other things. So it was very strategic for us to file it in Guam because filing this case in California or DC, there's really no understanding of the labor situation in Guam.
Mm-hmm. Did you have to get a bar in Guam for that? I mean, in a sense, what is the federal bar, or is there some local council you use for that?
Yeah, so it's an admission pro hoc vice, and you do have to have local counsel. So Jennifer Waters, who is an attorney in Guam and also an AILA member, is co-counsel on it.
Oh, wonderful. So you filed suit, you said 2015 or 2012 you started it? Oh, no, 2012 is when they started the denials. Around 2015 is when you filed the suit?
2016 was when
2016. And what happened after 2016? What's been the progression of that?
Well, we knew going into this that the only way to solve this was going to be to do a class action, because if we filed individual lawsuits, they would either delay them beyond the time that the H-2B was even valid any longer, or that they would approve that one case and just to moot it out. So we knew that the only approach that would work was a class action. The problem is class actions take a long time to litigate, and these employers needed immediate relief. So we went into the lawsuit knowing that we were going to file an injunction from the get-go, and we did. Interestingly enough, we lost the injunction. So what happens in district court is collateral motions can be delegated from the federal judge, the chief judge, to a magistrate judge. So we argued the preliminary injunction and the class action in front of the magistrate judge. and he denied our injunction. He found that although harm was clearly established, we couldn't create a sufficient likelihood of success on the merits. So when that order comes out, you then have 14 days to respond to the order before it goes to the chief judge. And we did. We responded, and it went to the chief judge, and she scheduled a second hearing on the preliminary injunction and the class action motion. So we sort of got a second bite at the apple, and then the chief judge granted the injunction. So in January of 2018, the injunction was granted. And what the injunction says is that USCIS is prohibited from denying any further Guam-based H-2Bs based exclusively on temporary need. You can deny it on other bases, but not on temporary need.
That was interesting. I was reading that. It was an interesting way to do an injunction for USCIS, like just take that off the table. I was surprised that they went that far.
Yes. And, our argument as to why they have to go that far is the purpose of an injunction is to restore the status quo as it existed prior to the change in policy. And the only way to really do that in an H-2B, realize H-2Bs are only good for less than a year. Mm-hmm. So in litigation, that doesn't work very well. So we also had to certify the class in order to avoid every case being mooted out because the labor cert is no longer valid.
Yeah.
So the injunctive relief ended up being really, really critical in the case because all of a sudden these employers, it didn't matter how long the litigation takes now because they can still file their H-2Bs. Mm-hmm. There's no question that they qualify. It's just an issue of temporary need. And so we have essentially two arguments that we raised in the class action. The first is that the government's just wrong. That their position is that if you're using this kind of labor year after year after year, it must therefore be permanent. And our argument is that these are recurrent workers. Every one of these workers is tied to a specific construction contract that is temporary. And that's the way it's been interpreted. That's the way the regs actually read. Otherwise, there'd be no purpose for recurrent workers to be in the regs. So we argue that the statute is just wrong. And then we also argued that the government had essentially created a legislative rule without notice and comment. So that's important because in order to get an injunction, you have to ask for something short of what you're ultimately asking for in the lawsuit. Mm-hmm. Because we are asking for the government to be found, their interpretation to be unlawful, that's essentially what we're asking for in the injunction. But the piece that is not part of the injunction is that you've engaged in rulemaking without notice and comment, and this policy should be struck down. So the injunction was granted January of 2018.
And how well did that work out?
Didn't work out well for the plaintiffs. They continued to file. Okay, so the RFEs were really interesting because they specifically referenced the lawsuit, and they said, we are giving you this detailed RFE so that we can comply with the injunction in Guam Contractors Association versus BAR, or whoever it was at the time. And so, I told the plaintiffs, I was like, look, you cannot respond to this in an iffy manner. You have to be really strong in your response because you don't want to give them an out for denying it. Yeah. So we submitted really extensive RFEs. There were 2 RFEs on most cases that we responded to.
So they sent the RFE, you replied, and they sent another RFE afterwards? Not a notice of intent to deny, second RFE, okay. So they're already breaking normal protocol, okay.
Exactly. And then sometimes they would do a notice of intent to deny as well. Mm-hmm. Other times they would simply deny it. And always the basis of the denial was you've used the workers year after year, and therefore it is no longer a temporary need. And then, they say their decision was, their argument as to why this complies with the injunction is we've given you a rational explanation. But it was exactly the same explanation that they had given before. So, we argued to the judge that that's not sufficient. And there was an intervening incident actually that happened, and that was that they started denying H-2Bs for temporary need early on, and the first one that got denied was not from a named plaintiff. It was from another company that was not one of the named plaintiffs. And I called the oil attorney and I said, you denied a case, it's in violation of the injunction. And the government took the position that even though the class was certified, the injunction did not apply to the class. So we had to litigate
What?
that. Yes.
A lawyer said that?
Yes, we had to brief and litigate the fact that an injunction that was granted did not apply to the class that was certified. It only applied to named plaintiffs. So there was litigation. We cleared up that the injunction applies to everyone, and then they continued to deny all of the cases, 100% across the board. So we filed a motion for contempt, which is very rarely done in federal litigation. Even the filing of a motion for contempt against the government it's very, very rare. But it was interesting because the government didn't have much of a response. Their first response is, we have sovereign immunity. And the obvious answer is, this isn't a damages case. We're asking you to be penalized for bad conduct. You don't get a reward for ignoring a judge's order. So we won on that issue. Then the other issue was, well, if you read it, we explain ourselves, but there was no explanation of yes, but that explanation doesn't explain a prior course of history that all of a sudden came to an end, and that's what the judge asked you to address. So the case was scheduled for oral argument before the magistrate, who had previously ruled against us on the injunction. So there was some concern about that, but it was quickly dispelled at oral argument because he really stuck it to the government on, their decision to read the injunction as narrowly as possible, and then try to weasel out of contempt motion, for that conscious decision. And so he really, really attacked them on that issue, and we felt very good about oral arguments. And then ultimately, we got the decision a couple weeks ago granting the order, for contempt and finding that sanctions are appropriate. But again, the government now has the opportunity to object to that report and recommendations, and that goes to the chief judge.
When is that hearing scheduled to occur?
It hasn't been scheduled. The government asked for a continuance of time to file their response, so their response isn't even due until, I believe, January 9th, or July 9th, sorry.
That's the annoying thing about this litigation. It takes forever to get the result.
It does. So.
And in the meantime, it's the same situation with regards to decisions, just denials?
Well, no. So here's the interesting thing now is, I think that regardless of whether or not, let me say two things. I think there's definitely an acknowledgement, one way or the other. I think the chief judge is going to find that the statute is clear, right? Or her order is clear on this issue. So even if she finds that the government's not in contempt, that she will have to rule that this is the only way to read this injunction to give it any effect. So I think the good news for the plaintiffs is, even if we lose the ultimate sanctions issue or contempt issue, I think they can start filing and hopefully have some confidence that those cases are now going to be approved.
Good. And what's happening on the ground level of these companies? Like, they don't have enough people. How are they handling with regards to just doing the work, and the thing you said, the mitigating damages from other their coworkers, the people they're working with, the vendors and stuff?
Well, the unfortunate thing is that this started out as a situation where contractors were really on each other's side on this issue, and they still are to a great extent, right? They still believe that this is an issue they have to solve. But what we're finding is that little businesses are getting squeezed out by bigger contractors with more power. So, you see a lot of situations where the ones that are ending up in default on contracts are the small businesses that can't compete for labor any longer. The other people that are suffering are, residential construction, civil construction, school construction, because all of the civil work is being pulled away by the military contractors because liquidated damages. So there's this concept of one Guam, in that, when the Marine base started, when the construction started, it was going to be good for everyone. Everybody was on the same page. And what the H-2B program has done is it has split, in a sense, the priorities of the Marines and the Marine base from the territory. It's created sort of this situation where it's definitely impacting the economy of Guam for the U.S. to take all those workers.
And the economy of Guam is already in a fragile state for many years. I mean, I
Exactly.
think it was Guam where they forced the minimum wage laws against there, and it just really hit them really hard. I think it was with tuna packing and stuff like that. So they already have their
Correct.
economy that's reliant on the Marines and the military bases there.
And the other thing that I'll say about the unique situation of Guam is, if you think about H-2B use in the United States, sure, it's there for skilled workers, but that's not really what it's used for. It's used for, more sort of temporary need resort workers, house cleaners, keepers.
I mean, the president was using these in Florida. He still uses them.
Exactly. So Guam is the opposite. Guam, relies on this for the higher skilled jobs. Those are the ones that they can't fill. So it's a really interesting situation that they're in, and they're very, very reliant on the H-2B program in order to survive, to be honest.
Well, thank you for your work. I'll definitely have you back on again to give us updates in January as they come along. But this isn't the only litigation you have in federal court right now in the employment sphere. What other kind of cases are you handling?
So we've got two others that are pending. Well, I should say two. One just settled this week, actually. So one of the things that people always are concerned about is retaliation from the government if you file a lawsuit. And so I have always told my clients that the reverse is actually true. If you start suing the government and the Office of Immigration Litigation in Washington, D.C., sees your names on pleadings, they will know, and that trickles down to the service centers, possible litigation, which either means they have to really give a good decision, good for them, that's their job, or two, they know that I'm going to sue them if they mess up. So the reverse is actually true. So here's the interesting anecdote: is that the attorney that I've litigated against in the Guam case since the beginning is a man named Glenn Geardharry, who is an attorney at Oil, very professional. I've really, really enjoyed working with him. But I think he's a little hamstrung by the government in this case, by one agency, and I think he's in an awkward situation because other agencies are supportive of the litigation. But I filed an L1A denial. This was a 3-time approval, L1A status. On the 4th filing, it got denied. Denial. You're not managing people. You don't need somebody of your caliber. You're only making $84,000 a year. You're not really a manager. Simultaneously, there's an I-140 pending, and we just got an RFE on the same issue. So there's a concern here because, number one, the clients are now out of status. There's been a decision, they're accruing unlawful presence, and possibly the I-140, even if we file a 485, if the I-140 gets denied, we have a problem there. So the client in this situation really had no choice but to go to federal court. Filing an AAO appeal was not.
That's not happening, yeah.
So we did, and the client wanted to file a TRO right off the bat because they were concerned that, number one, they can't renew their driver's licenses. They have a company that relies on loans, and they can't apply for loans if they don't have a driver's license. So there was a lot of reason why they needed a TRO. They needed immediate relief. And I talked them out of it because I knew that the case was strong enough that it should settle, that I knew that the filing of the complaint with the U.S. attorney with the evidence would be sufficient for them to make a phone call and say, you should reopen and approve this case within the 60 days that the government's response was due. But if I file a TRO, it gets sent up the flagpole to Oil. And that's not good because they are more likely to dig in their heels on immigration cases. So I talked my client out of filing a TRO. I was positive that this case was going to be reopened and settled without any fuss. And sure enough, on the 60th day, they filed a skeletal reply. The typical, we deny this one, we have no basis to know this one, typical skeletal response that answered it, doesn't even need a reply. But the attorney that filed it was Glenn Geardharry, the same attorney that I was litigating against in Guam. So I emailed him and I said, Glenn, I was very honest. I said, Glenn, I'm actually surprised that the government is pursuing this. And I was very honest with them. I said, I thought this would settle. I don't think this is a good case for the government in terms of the precedent that it's going to set, but that's your call. And I said, however, you should know that I talked my client out of a TRO, but now that you filed an answer, I'm going to be filing a motion for a TRO on Monday. And I'm also going to file a motion for summary judgment at the same time. And sure, he said, give me some more information about the TRO. And I explained the situation with driver's license. And within 24 hours, the case was reopened and approved. So
I-140 still pending?
I-140 is still pending. So,
we may status to figure that out. Yeah,
exactly. And we may get a denial on the I-140 and we'll go back to federal court, but we'll see what happens.
It's crazy.
And then the other case that I had was a similar situation where an L1A manager, he got approved for his L1A several times and then filed the I-140. And of course, the I-140 gets denied that you're not a manager, you don't blah, blah, blah. So we actually appealed that one to the AAO. At the same time, we filed a new I-140 because for the time that the I-140 had been pending, his company had grown significantly. So we filed we had one I-140 pending at the service center and one on appeal at the AAO.
Okay.
And we won at the AAO. The case got remanded for a new decision. And both I-140s got approved on remand. So it was one of those cases where it was good to go to the AAO.
When they remanded it, did they have new accusations that you had to reprove, or USCIS just approved it once they got it?
They basically said, we believe that you've established eligibility.
Okay.
Please render a decision accordant with our position.
Okay, it was a full-on, we approved it. Okay.
Yeah. So we had to go to the AAO in this case because we made the stupid decision to let the client's L lapse and have him work on work authorization. So there was a period of out of status that we were concerned about. So we sent him outside the country to get a new L and come back in. So we really had to go to the AAO in this case. We couldn't go to federal court. But here's what happened. So the I-140s both get approved. They simultaneously reopen and approve the dad's 485, but the wife and kids are in limbo. And I call the government and I say, you haven't approved it. And they say they were not part of the lawsuit. So, because there was a threat, obviously I had called Glenn and I said, I'm gonna file a lawsuit if this doesn't happen. And so anyways, so we filed a mandamus on that one, on the mother and the kids, and sure enough, the filing of the mandamus within 2 weeks, it was reopened and they all got their green cards.
People got to spend thousands of dollars because of this garbage. It's evil. I mean, like, come on, why do you got to put people? It's work for us, but this is the kind of work we want to do. This is such a waste of everyone's time.
Yeah. Although I will tell you that the more you do it, the more you can expense it across clients, right? So where I used to charge, $10,000 to even go into federal court, I'm filing these mandamuses now for flat fees. And, and I say, look, I think it's going to settle. If it doesn't settle, it's going to be this much. But most of these cases you can price out for a much less price because the government's going to cave on them.
Yeah. Well, good stuff. That's important news. And I'm glad you're doing this work and coming on board to let everyone know that this is what you got to do. Honestly, if we have more people not being afraid and pushing it, they're going to get the message that we're not going to sit here anymore and deal with garbage decisions, especially how elevated, how much more. I mean, you see the denial rates going up for L's and H's and our RFE rates going up. And they're just crazy things they say in there. So obviously they don't read them, or they got some sort of script that they just put out regardless of what you sent in. It's just unjust, If a case isn't good, it's not good to deny. But the stuff that's coming out is just ridiculous. And the H-2B case you have is a great example where they're really I'm sure the military and their construction right there is getting hit by it too. Even if they have the staffing that's getting away from civil projects going to military stuff, they're still going to not have enough people. If someone gets sick or something happens, there are less people. So it's shooting national security in the foot. And that's the whole goal of DHS has been national security. That's our focus now. USCIS national security. When they talk to officers, that's the first thing they say. It's not about service, national security, but they're undermining national security in this way. One of many ways that USCIS and DHS are doing that over and over again, we see.
They're also putting workers in danger because, if you can't get skilled labor, you train up somebody really quickly on something that they're not prepared for. And it's very dangerous.
They're making a military set. I mean, if you don't make a runway properly, that F-16 or F-20, whatever it is, a multi-million-dollar craft is going to hit some sort of bump or something and crash and risk lives and treasure. So it just it doesn't make sense. But the politics has gone so enmeshed into every aspect of immigration. It's just so nasty. But thank you so much for coming. If someone wanted to contact you, reach out to learn more about this and maybe send you a case, how would they contact you?
Probably email is best. My website is immigrationissues.com, and my email is jeff@immigrationissues.com.
Did you register your domain name early on when the internet came out? Because that's a wonderful name to catch a
I want to say it was 2000, and there was a lot to choose from, and
wow.
I wasn't sure if I'd get into policy work or stay as a lawyer, so I didn't choose immigration cases.
Yeah,
that was available. It was pretty crazy.
Jeff, thank you so much for coming on board.
John, thank you. Appreciate it.